Hello. I'm delighted to host a timely, as we promised, 20 minutes conversation with Barry O'Leary. He's a leading UK migration solicitor at Wesley Gryk Solicitors LLP and director of Micro Rainbow. And Barry recently provided an oral evidence to the House of Lords Justice and Home Affairs Committee on 2nd day of December on the government's proposal to overhaul settlement routes, bringing to discussion risk to integration, family life, and essential sectors. So the government's fair pathway to settlement consultation proposes us a baseline 10-year qualifying period of ILR with the potential reductions for high contributors or increases based on the factors like public funds use or migration breaches. So changes are intended to be applied retrospectively to most existing visa holders with implementation expected from April 2026. So, Barry, thanks so much for being with us today. You've been deeply involved in both the practical and the policy side of migration law. And at the moment, when settlement routes are undergoing some of the most significant proposed changes we have seen in years. And before we unpack what these reforms might mean in practice, I'd like to take a step back and ask about your own journey into this field. So, exactly what originally drove you into migration law, and how has your experience, particularly around family and human rights cases, influenced the evidence you recently gave to the House of Lords?
Thanks, Burak. Thanks for having me along. Wow, how did I get into it? I was also always really interested in issues around asylum and the rights of individuals, and I was also very much interested as a younger person in LGBT rights as well. But the honest answer is how I really got into it is that I myself fell in love with somebody from abroad in the mid 90s, and because I'm a gay man, I was left with a situation where like we had no rights whatsoever, and our relationship wasn't recognised, and so it kind of combined my
Hmm.
passion for like rights and also my personal circumstance. I have to be quite honest; it was quite self-interested, but
Hmm.
26 years later, I'm still actually doing the same thing. So I did broaden it out from just actually sorting out my own personal situation. What it means is, I'm going to be quite clear with everybody who's listening to this. You'll probably come away from this say this man has told us nothing new,
Hmm.
because the truth is, even with like 26 years experience and having gone through so many different changes in the immigration rules, this I think this consultation is vague. I think it's scary, and I can't really reassure people.
Yeah.
And I think at the moment there's a lot of, well, we think this is what it's going to be. We think this is what it's going to be, and I think where's my 26 years come that we sometimes have success. We do sometimes change things a bit.
Hmm.
We've usually been unsuccessful in changing the thrust of things,
Hmm.
but often we've managed to mitigate them a little bit. So I would say I'm pessimistic. My experience shows I'm pessimistic about a lot of it, but optimistic that we can maybe change some of the information that has been put out.
Hmm. Hmm. Thanks so much. This is very really helpful, actually. Um, I'm going to turn now into the substance of the government proposals. One of the key ideas being put forward is notion of an earned settlement, so-called, with a NEEV 10-year baseline and a different adjustment depending on a person's role, income, or migration history. But as you highlighted in your evidence to the House of Lords, the way these categories are drawn can produce some unexpected and in some cases deeply concerning outcomes. Face the standard 10-year rule who might see that period extended or reduced, for example, care workers or refugees, or and what kind of inconsistencies or perversity sort of arise, particularly for dependents or people with mixed migration histories here.
Yeah, I think it's really interesting. I think one thing I'd say about this is that what's unusual about this consultation is how many groups it impacts upon. We're quite used to dealing with, say, family members in this consultation, or skilled workers, or refugees. And what's happening here is everybody is impacted.
Mhm.
So I think there is two things I would say, and I'll go on to perversity, but I would also say, I mean, the bottom line is it's just unjust. I
Mhm.
mean, it is on the whole, just a massive increase in the a massive increase in how long it will take most people to get to indefinite leave to remain. And that I think is just unnecessary and not based on any evidence that there's any benefit to the UK
Mhm.
of doing this. Perversities, what would I think? Um, I think let's take refugees. We are you will be penalised for, as we know now, in lots of ways before your route of entry, but we don't have safe and legal routes. So in the main, but for instance, now it appears that you'll be on a 20-year route unless you can move into this protection and study work, which might reduce it. So some refugees will be able to get there more quickly, which is great for them. But I'm really unsure why people who maybe the most damaged refugees, the ones that have actually had the worst experience before, the ones that maybe actually aren't able to study or work, they are actually going to be penalised for that. And I think straightforwardly that is perverse. But on the ones that I sometimes use, it's terrible. Like with people nearby where I live, the way I explain one is the perversity of the family rules. As they're written, it appears to me that, so say you're here like as you're the main worker
Mhm.
and you're the main skilled worker, and maybe you're lucky enough to earn like £170,000 or whatever, and you're fast tracked through to your indefinite leave to remain. I'm
Mhm.
quite sure what happens to the partner who's staying at home and looking after the kids who doesn't earn any money. They seem to be like, well, that's not important right now, and you can go on for indefinitely without actually reaching your own status.
Mhm.
I have to say, it seems completely perverse and also leaves that person in a really unsecure immigration situation. We always like to bring people to a point where their immigration system status is vested in themselves rather than actually dependent on a relationship or this. And this is just extending it so much further. I think perverse, I don't know if it's perverse, but I think there's lots of things they haven't really seen. They haven't seen the knock on to nationality law, where there'll be a lot more children who were born non-British, that there were a lot more migrant children who may have come here at an early age who won't reach indefinite leave to remain and therefore might be barred from the British education system because they won't be able to access like home fees. I think whether it's perverse or not, but I think there's just a lot of groups that won't. I'm not sure they understood the impact.
Yeah.
And this is that I think is quite perverse. We have for years tried and said, and this is absolutely right, let's regularize people's status. If you've overstayed, let's go and I'm going to send you back to your country of origin and make you come back in with the right visa. As these rules are written, are they going to be still penalised even though they've, in the government's eyes, done the right thing? It looks like they might be. It looks like they might be. And I think there's a lot of stuff here that I the people writing these rules don't have as much experience as probably the people in the room that are listening to me, the people who are listening at home to me. And I think it's incredibly frustrating, but that's why we have to answer the consultation. So I've whittled on about that book. Burak, carry on.
Yeah. So, I mean, I'd like to ask a question about like, as we know, for many migrant families, the prolonged periods without settlement, I mean, as you say, don't just mean the ongoing insecurity, they translate into sort of very concrete consequences. Children may grow up and spending most of their formative years in the UK without like stable status. Families can remain subject to no recourse to public fund conditions for far longer. And young people who see themselves as British may suddenly find themselves treated as sort of international students when it comes to uni fees or access to student finance. So there are also broader questions about the long-term effects on children who are born in the UK to parents who are pushed further away from settlement, including whether we risk creating larger cohorts of children growing up without citizenship, secure status, or equal opportunities, as you mentioned. So, how do you see these extended timelines exacerbating child poverty, limiting access to home student fees, and sort of affecting both the existing and the unborn children, particularly for families living under the no recourse to public fund conditions?
For the children, and I mean, right up to the age of adulthood, I am worried, and this is not my expertise because I'm a lawyer and look at the rules. I'm worried about like cohesion, and we talk a lot. The political rhetoric is a lot about people integrating, whatever that means, and people cohesion, and yet they seem to be very much against that. It's almost keeping children separate. If you keep children on a insecure pathway, then they're, by definition, they're being treated very differently from their British citizen counterparts. I want to go back to property, but what I would say, and I think this is really important, is that we don't, if these rules are as bad as we think they're going to be, we don't just throw our hands up in the air and go, there's nothing we can do.
Mhm.
For instance, we have to think about with these children whether we can get them to British citizenship even without settlement. There is nothing in the Nationality Act that says you have to have settlement before you register as a child. Now, Home Office guidance expects it, but we can make arguments about children getting to citizenship aside from the immigration rules. And I think it's something we really need to remember. In terms of child poverty, I'd say one throwaway thing, which is quite worrying, but not in the rules, is we've anecdotally seen reports of people thinking, well, I can't access benefits because this will extend my indefinite leave to remain period. And it's like, well, this is terrifying. If you actually do have recourse to public funds and it is a judge that you need benefits in order to survive and support your child, well, then what a disaster and what a straightforward way into poverty if people then don't access those benefits in order to ensure that they get to indefinite leave to remain more quickly. It will mean people, even more children living under the poverty line. So yeah, I am worried about child poverty. I'm worried about them not being integrated in the same way, and I'm thinking they're being very like they're very separate. They're treated as a separate kind of part of our society rather than on a track to be absolutely part of our society.
So the many of the impacts we've been discussing, particularly on children and families here, are not, I think, just about the substance of the proposals, but also about the like process by which they're being developed. So the government has emphasized that this is the public consultation. So, I mean, yeah, the timeline is extremely tight, as we know, with the consultation closing on 12th of February and implementation potentially beginning as early as April. There appears to be sort of very limited space for meaningful scrutiny and parliamentary debates or sort of proper engagement with the evidence submitted. So, for a reform of this scale affecting sort of hundreds of thousands of people, including those already in existing route, the way the decisions are made can just be as important as the decisions themselves. So, what concerns do you have about the current time frame for scrutiny, and how might a rushed process undermine the fair consideration of consultation responses or expert evidence here?
My concerns are one, they've made up their minds already, and this is just an exercise in having a consultation. I have to say, even if that's the case, we don't know it, and people have to still respond. And so, even if you feel like you're whistling into the wind, or screaming into the wind, even, we still have to respond to the consultation, even if they're not going to listen. And I know that feels like, well, why would I waste my time? But we have to. It's all we've got, and we still have to contact our MPs, and we still have to we still have to do our own consultations, contact our MPs, and get other people to do consultations. I'm very worried that the rules could be really, really badly drafted. We've seen too many examples over recent years where there were some great civil servants. I need to be really, really clear here. There were some really good civil servants who are really committed to their job and really committed to getting clarity. But if the politicians, the government, give them an impossible timeline, then with the best will in the world, however good they are at drafting, they're going to come up with ill thought through rules. We should really be, and we've always said this to them, do the rules, then show them to us. Show them through our professional organisation, the Immigration Law Practitioners Association, which they have in the past with some proposals. And we will actually comment on them, and we'll come back to you and say, well, do you realise this means this? And do you realise this means that? It's a really good process to try and actually try and come out with the best rules. Even though we might not like the policy, at least we can actually have rules that are clear. I am worried that if they really try to stick to April, then we are going to get. It means they're not really going to listen, or they're not going to have the rules are going to be poor. Now they have left themselves a bit of wiggle room here. It says a rollout from April. So I don't think we should necessarily think everything's going to come in then. And if we make enough noise, and if the MPs that are on our side make enough noise, maybe we can actually delay it, and maybe we can have something a bit more considered. There are processes in place that can actually delay through the laws and laying motions in Parliament. I can't, off the top of my head, explain it exactly, but the problem is traditionally we've seen very little resistance to immigration rules coming in because they're not done by kind of a primary legislation that gets debated in the same way. They're laid as a secondary instrument, so often it's kind of happened. And also traditionally we always get 21 days before they come into force, but increasingly we've seen this tactic used, which is we are going to bring them in immediately. And the reason they do it is they don't want these awful people somehow using the rules that are in place already to actually before they change. That's not the worst thing in the world for somebody to actually make a considered decision to apply at the time when the rules are they can meet the rules. Hopefully they won't do that this time, but we never know.
Mhm.
So, in answer to your question, Brock, I'm worried that they are not listening and they might be rushed. But with a lot of noise, maybe both of those can be changed.
I've been spending loads of hours to sort of give organization advice to how to fill the sort of consultation forms these days, but hope for the best.
And I think that's a really, really, really valuable thing you can do because it's kind of all we've got at the moment. Like telling people about this, getting people to answer.
Just getting people on board in sort of WhatsApp groups, Telegram groups, sort of fill in,
Yeah,
actually like talk about who you are and what your
yeah,
concern is rather than just you text to me.
yeah.
And obviously, like so far, we have talked about the practical and the human impact of these proposals, as well as the speed at which they're being developed. I'd like to now turn to a legal framework within which all of that sits. It's so far clear that the reforms do not operate in a legal vacuum, as I'm understand from your remarks, that they intersect with the long-established principles under domestic and international law. So, including the right to respect to private and family life. So, we've got Article 8 ECHR. We've got obligations under the Refugee Convention to sort of shows us the terms of the integrations, and then we have got the structure of the British Nationality Act 1981, particularly in how children get their citizenship. So there are also broader rule of law concerns here. Many people currently on the 5-year routes were granted leave on the basis of the clear expectations about settlement timelines, just as in the EU. So, retrospectively, extending those routes raises a lot of questions about some legitimate concerns and expectations. And people talk about legal certainty, whether such measures can be justified as proportionate, especially where family life has already been established in reliance on these existing rules. So, against that backdrop, what legal and human rights risk do these proposals pose? Uh, in light of considering the Article 8 of the ECHR and all the other sort of regulations that I mentioned,
Yeah,
uh,
yeah.
uh, retrospective applications here. Is it
I think
proportional?
that yeah, taking them all in turn. I think Article 8 is a really important part of our of the system that we have. It's not as it's portrayed in the media, like some kind of like, charter for foreign national prisoners to remain in the UK. I mean, it's such a tiny drop in the ocean of it. It does actually facilitate a lot of family situations that don't quite fall within the rules. But they clearly are meritorious and those people should be allowed to stay. The issue with Article 8 is that most of our jurisprudence up until this point, and it has been debated and it's gone through the courts and it goes up and down, and it's a fascinating subject in its own right. The Most of our jurisprudence, in my view, is about whether people get to remain in the United Kingdom.
Mhm.
So nearly every Article 8 case I have ever done, in fact, I think I can pretty much say this, has been about can they stay or do they have to leave?
Mhm.
Now, what we're looking at here for the future is going to be not is not that's not going to be the debate. It is, are you interfering with their private and family life by actually keeping them in this position for such a long period of time? Now, to my knowledge, now I'm not a barrister, and I have a very practical approach to law rather than a very, very, very case-based approach to law, jurisprudential-based approach to law. This is actually going to be quite new for us because it's going to be a slightly different concept. Is that you're the what they're doing is impacting. And I have to say, the example that we've used here really well, I think that I've used before, but I'm going to use it again, is actually the young adults who are not able to go to, say, university or do certain jobs, etc., because of their non-permanent status. I think that is going to be an interesting area.
Mhm.
In terms of the refugee aspects, I think we really are going to have to argue the Refugee Convention and say that we're supposed to be integrating people, and this seems to be an anti-integration measure. And I think that's going to maybe a challenge on that basis. Legitimate expectation is such a interesting one, and it's like I think clearly there are going to be claims on this basis because if you forget the law for a second, just think what's right, what's just.
Mhm.
To have rules in place that say we are going to allow you to come to the United Kingdom as a care worker, and let's be honest, not because we're really nice, but because we need care workers. We're going to allow you to come, and this is the deal. This is the deal. You're going to be the rules in place say you're going to be. You came in 2021. By 2026, you don't commit any crimes, etc. You still have your job. You're going to get permanent residence. And then in 2026, we say, oh, hang on a second, it's going to take you another 10 years. Clearly, forgetting the law, it feels unjust.
Mhm.
people who are cleverer than me are going to take these cases and they are going um, to fight them with every tool they can. And I imagine that will be a mixture of legitimate expectation, Article 8, etc., etc. I can't say now exactly what the grounds are going to be, but will there be a legal challenge? I think undoubtedly there'll be a legal challenge. Will it be successful? I don't know.
Mm.
But there will be a legal challenge to it.
Actually, you highlighted very well to say that like rather than the last decision, the process itself is a bit sort of questionable and problematic
Yeah.
and very prolonged actually as well.
And yeah, I'm going to say about the British Nationality Act again. I truly think that it's going to get forgotten about quite a lot, but I'm quite keen on saying this. When Parliament enacted the British Nationality Act in 1981,
Mhm.
they were talking about a world where parents got settlement really, really quite quickly. And therefore, when children were born in the UK, they thought, well, their parents need to be settled. But what they were really looking at were these people who weren't here really, really temporarily. They had no concept when they decided this that we would be talking about parents who had lived here for 12 years, for instance, and their children born in the UK were still not British on birth. They could never have envisaged that when they were passing the act. And I have to say, I don't think parliamentarians looking at this now are understanding that we're actually going to be denying so many children British citizenship on birth who are born here and who clearly, to all intents and purposes, British, apart from not being a British citizen. And I in all the other things, I really don't want that to get lost because I think one, it's really important, and two, I think it's quite powerful. I think people, you talk to an average person who still says, "Oh no, but you're British if you're born in Britain, aren't you?" I'm like, "No, you're not. We don't have birthright citizenship. What are the rules? Well, your parents have to be settled." Okay, but yeah, okay, I see that. Yeah, and so actually, your parents might have been here for 14 years, and yet you're still not British. I think your average British person, even with the rhetoric that we've had for many, many years, would still think that was actually wrong.
It's sort
And I
of
think we need to keep making that point.
it's really sort of creating a second class sort of citizenship
Absolutely,
without naming it
absolutely.
actually. And like
Yeah.
I think there are going to be a lot of emotional instabilities in the families.
I
Should
think I
I
think it's right.
continue to that school? Should I do the spending sort of? And even the family formations, like should I get married with a person with an ILR or just? I
Well,
mean, I receive a lot of questions on the inbox, and I can't put into this interview. This is sort of very sort of parliamentary evidence kind of interview.
yeah.
But, but
I
obviously,
think it
it's
is, and to be the British-born child of migrants is just something we've had for years, and we've always accepted those people are British. I'm British. I'm the child of migrants from a long time ago. But it's to then be having people not British citizens, even though they've got a Brummie accent like me, and done everything from the beginning in the UK. They were born here. It's just wrong, and I think we need to make sure that challenge is done.
bringing like loads of uncertainties, especially regarding the skilled workers. I mean, or some sort of care visa people. I mean,
Yeah.
15 years and all sorts of
Yeah,
prolonged delay.
and
It's a
and I
big.
have to say, Burak, I'm probably not making it clear enough when I do this. I have to say, when I'm talking, I'm often talking about the children of scale. But that's why I'm using 15 years, because even though I'm very concerned for everybody, I think the thing that probably gets me most exercised is actually the care workers, because I think this is appalling, and I know that we're recognizing we're doing it all by money. It's like how much money have you earned in the last 3 years? Now I do realize that some public service jobs are going to be recognised, which is great, and they should be. But I think we all need to be very clear that care work is a public service in the UK. It absolutely is, and even if they're in private employment, and I think the fact that they are being really, you know, they're not going to be able to get any reductions, etc., because they're just not going to earn enough money. That's it. You
So
know.
I'd like to now, thank you for this, now turn a bit of a policy rationale here in this proposal. Like central claim made by the government is that extending settlement timelines from 5 years to 10 years more. We've been repeating this a lot today, but they say will help to reduce net migration and limit long-term settlements. So there appears to be very limited empirical support for that assumption as well. And in particular, the data, the comparative data suggests that migration levels remain remarkably consistent across very different legal systems. So we heard that around 3.5% of the global population lives outside their country of nationality. So regardless of whether the countries operate highly restrictive regimes and far more facilitative ones. So there was also another evidence indicating that many migrants and refugees have little understanding of settlement rules at the point of movement, calling into
Mm.
question whether long routes meaningfully influence initial decisions to come to the UK. So at the same time, the proposals are risking sort of increasing the burdens on the Home Office staff and on the government. So with more frequent applications and a potentially higher long-term system costs without clear expectations of and also how this translates into the bureaucratic system. And so, given all these contexts, what evidence actually exists to support the government's claim here, extending this qualifying period to 10 years? And
I'm not aware of any. I'm not aware of any. That's my simple answer. I'm not aware of any. Now, I'm not an academic. I'm not a wonderful organisation like the Migration Observatory in Oxford or whatever. I'm not an academic, so there could be something out there that they are really aware of.
Mhm,
But I'm not aware of anything. Now, I have to say, it doesn't really come into my work. I very much really focus on the practical stuff. But I do not see the policy objective driving this because it's all about people already in the UK.
mhm, mhm,
Now, maybe, and I have to say, I don't know this at all. Maybe there'll be some skilled workers who would make a decision about when they're deciding where they want to go. Maybe that would happen, but probably I'm not sure. Anecdotally, with my Micro Rainbow hat on, if people don't know, Micro Rainbow is an organisation that helps LGBTQI refugees and asylum seekers. I've had a meeting with them about it, and the refugees themselves and the skilled workers say, "Look, it's wrong. I tell you now, we do not think it will have any impact on the decision
mhm.
at the time of arrival in the UK. That's not what people's concern is. Their concern is to get safety. It's so all it does is actually extend it without any impact. And I have to say, you make a really good point here, Burak.
Mhm.
If they really are going to take asylum seekers through 2.5 years or 20 years, they're just giving themselves so much work to do, so much work in an already overburdened system. It's just really nonsensical.
Mhm, mhm. I think it's not going to be an individual failure. I mean, if we bring the structural failures, we're going to see a lot of unpaid people who's desperately wandering around there as well. So I don't know
Yeah.
if it's sustainable for children, for disabled people, for sort of
Yeah.
other systematically excluded people. Maybe they're not just refugees, obviously. This umbrella is very broad. And
Yeah.
I'm wondering, like, also, the other question sounds a bit. I'm going to simplify the other question. Obviously, the government's talking about Danish models, and then they're citing the Danish model. But um, what lessons can we learn from the Denmark sort of example? Is that going to be misapplied in this case as well, if they bring some of the points here?
I mean, my quick answer is I don't know enough about Denmark. Um, what I will tell you is over time, different governments, and I have to say, a lot of my comments are really quite apolitical because they apply to the Labour Party just as well as they apply to the Conservative Party. Over time, the government does get quite keen on other countries' systems. Um, if you went back and saw how many times ministers of all different parties have said an Australian style points based system, I'm absolutely obsessed with Australia for quite a long time. They seem to have moved into that with Denmark. I think what we would say is, as a grown-up civilized country, we need to look at our own circumstances, our own needs, and how our migration works. For instance, let's talk about the skilled workers again. Denmark is part of the European Union. Denmark has freedom of movement with countries of many other countries. They have a completely different migration labour market than we do. We don't have that. The only freedom of movement to the UK is for Irish citizens. That's it. And so to straight away, you are not comparing like with like. You're comparing a country where migrants from 26 countries can move to tomorrow.
Mhm, mhm.
So I think they don't quite get what they're doing there because if Denmark does one thing, they may still have a I'm not going to name a country. They may have a care worker from a country that is not as wealthy as Denmark come in, and they will have permanent residence after 5 years. So please, so straight away, I would say, don't tell me that a care worker in Denmark doesn't get status after 5 years, because they may well likely get that status because they're from the European Union. We have cut off that workforce. And let's be honest, the reason we have lots of care workers is because we left the European Union. it was exactly timed that we reduced the immigration rules that were the requirements of the immigration rules as we left as on the Brexit date on the December 2020. That's why we did it. So it's I don't think it's comparing like with like.
Mhm. I think rather than talking about the economic prosperity or sort of economic data here, they're talking about the temporary side of maybe asylum or newcomers, like everything should be
Yeah,
temporary. And then, but nobody talk about costs, harms, or
I
sort of
think
some.
yeah. I I also think there's sorry, I get a bit annoyed about this, but I do think it's just something they've hid. Successive governments are hidden behind. There are absolutely look at other countries. We should look at other countries and see what countries other do well, don't do well. We could do that in lots of areas in terms of drugs law, in terms of this law, in terms of all sorts of law. We could do it. But look at our own specific facts and look at whether this is fair. Don't justify it on whether Denmark's doing it. Justify it on whether it's fair to the people who are here in the UK. Because actually, I do come from a time when we thought we were really good at being fair and being really decent. And actually, we were quite proud of it. And we kept repeating, oh, we're so generous, we're really tolerant. Well, actually, maybe let's show it rather than actually using another country to justify our harshness and our inhospitality and our intolerance.
So in terms of the Denmark example, one thing is coming to my mind is that, I mean, if you're in Denmark, you have still got the sort of free mobility all around to Europe as well. It's not that restrictive, but in the UK,
Yeah.
it's a big change happened
Yeah.
after Brexit. So as an anecdote, I just want to
But
give.
I
Oh,
should add to that, I don't know enough about Denmark. And I actually said this to the House of Lords because they asked me questions about can I compare this with this? And I'm like, no, I'm a UK immigration law. I can't.
mhm, mhm,
I think sometimes I'm a bit disappointed about. I feel like I have to apologise for my limitations. It's enough for my brain just to understand UK law.
mhm, mhm, mhm. So I don't want to bring this retrospective viewpoint question, and
Mm.
obviously we previously talked about how it's going to disrupt the lives, but um, what other sort of human rights based claim that we can provide evidence regarding this retrospective angle as the whole families, as the whole sort of ordinary sort of change makers?
Um, I mean, I think what we should do at the moment is be making the arguments about whether it's right or wrong. I
Mhm.
think the legal arguments can go in. I think that's right, but I think really they are also for later on is when they're going to come into their force. I think for now we should be saying we people were invited here under these rules and we are now changing them while they're here. It's not fair. And maybe that's a bit of a cop out. You want a more legal answer, but I think that's our strongest point at present.
So there's one thing is so interesting. I mean, they put some requirements to people that you have to show what kind of contributions you're making, and then regarding to be able to sort of pursue the ILR. So what's your take on this?
I think we don't understand enough what they want.
Mhm.
Because there's one thing there, isn't there, about volunteering or something. And it's like that's so vague that it's really difficult for us to say exactly uh, what it is. I'm just going to actually just try and find the term because I've forgotten the term about volunteering. But it is so we've got all the penalties, and this
Mhm.
applicant has worked in the community. And I'm not volunteering, etc. I'm not really sure what it is. So I think it's quite hard to talk about these reductions and penalties and these earned requirements without without with any certainty.
Mhm.
What I would say is I think I do take exception if it really is very, very, very financially based.
Mhm.
Maybe in a modern economy that people say to me, that actually is a reality, just get over it. And maybe I have to accept that. But I think if that's one thing, there should be enough other types of reductions.
Mhm.
I think the problem with the reductions is that I think the whole basis is wrong. I think just increasing the baseline is wrong in and of itself.
Mhm. Mhm. So at the beginning of the conversation, I just promised each other that it's not gonna exceed sort of 20 minutes. So I
Yeah,
can come back
sorry.
to
Yeah,
my
we must. I've
last,
ranted on a
maybe,
bit.
yeah, maybe the most impactful questions, based on your answer, obviously, it's gonna happen. What do you think about the potential upcoming judicial review case? Do you have any sort of consortium team behind you to prepare to this? Or how long does it gonna take in a worst case scenario for a judicial review to be successful?
You mean an existing judicial review or judicial
No,
reviews in the
after the
future?
April, once the rules are implemented, actually. In a worst case scenario, I mean. as it is in the white paper.
Oh God, I don't know. I really don't know. I have to say because it would depend on whether the High Court was willing to deal with things more quickly, etc. Luckily, as well, on my I very rarely have to go
Mhm,
to judicial review because my cases usually
mhm,
settle on the point when I say I'm going for judicial review. So I very rarely actually get into the High Court. So it'd probably be a question for a barrister to answer. They
mhm.
do have the ability to bring things forward very quickly if they think that it's important to do so. If you see, for instance, the case about the hotel in Essex, where they did actually, the JR got in really, really quickly, even though usually you'd expect a long time. So I think it's quite hard to actually say how long it will be. I think what we need to do, though, and this is really hard, is wait and see what the rules say, and not try and think exactly what our arguments are before the rules are there and see how they're impacting people.
So yeah, I'm gonna encourage a lot of people to watch this video. Hopefully upload it to YouTube. Thank you for your valuable time.
Okay, and
Really
it was lovely to meet
enjoyed
you,
it.
Burak. Okay,
Thanks
I
so much.
best go, but
Thanks so much.
thanks a lot. Bye bye.